inquiry into espionage cases and the Official Secrets Act following the collapse of the case involving the alleged spying activity for China. Our objective from these sessions is to bring clarity to questions that have arisen in recent weeks, to ensure proper accountability and review the adequacy of processes and decision-making. It's unusual for us to examine the details of such a case, but it is warranted given the scale of public concern. So we're going to be hearing from officials today and ministers on Wednesday morning. I'd like to remind witnesses of their obligations to Parliament and the expectation of providing as complete answers as possible. So perhaps I could start by inviting those present just to introduce themselves.
Thank you, Chair. My name is Stephen Parkinson. I'm the Director of Public Prosecutions.
I'm Tom Little, KC, First Senior Treasury Counsel, and was the instructed advocate in the case that's the primary issue of your concern.
Thank you. Stephen Parkinson, the situation we find ourselves in is quite extraordinary. Who do you think is responsible for the collapse of this case?
First of all, Chair, may I say how disappointed I am that this case could not proceed to trial. I recognise and absolutely endorse the points that you have made about the nature of this case, and in particular the level of public concern. And I'm very conscious indeed that there were two victims in this case who were members of the House of Commons, who were the victims of a gross breach of trust, as was Parliament itself. In terms of your question, if I may say so, I don't think it is a question of blame. The responsibility of prosecutors is to place cases before the court on the basis of sufficient evidence to secure a conviction. And ultimately, the issue in this case is that we were not able to provide the evidence to sustain the case in respect of one essential element, which was the element that China was an enemy, as was required by the statute.
Do you think on that point, do you think there was or did you ever get the feeling that the government wanted this case to fail?
Nothing reached me. I should, I'm sure it's known to many members of the committee, but if I may just explain the division of responsibilities in terms of criminal cases. So we don't investigate cases. We look at the evidence and we make decisions about whether it meets our tests. But the relevance of this to your question is that until a very late stage, we weren't engaged directly with any witness. That was the responsibility of the police. So I do not know anything about the background to the statements that were produced. Our responsibility was to look at the evidence, to ask investigators to obtain more evidence if that was possible, and then evaluate whether our tests were met. And the key test for prosecutors is the evidential test, which is there a realistic prospect of securing a conviction?
So you felt that you didn't have the evidence that was robust to put before a jury?
We did in the first instance.
What changed?
What changed was the ruling in a case called Rusev, which imposed an additional requirement. So, as I've explained, one of the elements of the offence was to establish that China was an enemy. And our route to doing that was to frame a case on the basis that China was a threat to national security.
Threat or an active threat?
Well, at the time, a threat. The difference that Rusev, which was another case based on the same prosecution theory, in fact, of threat to national security. There was a ruling in that case which said that you can mount a case on the basis that, in that instance, Russia is a threat to national security, but you have to show that at the material time it was an active or a current threat to national security. So the statement that we had at the time in our case didn't go that far, so we asked for confirmation that at the material time, which was the dates of the offence, China was an active threat to national security. That we did not think that this would be a difficulty, but in the end it proved to be a sticking point, and we were unable to secure that evidence.
When you decided to drop the case, what advice did you take before coming to that decision?
Well, there was an enormously experienced team involved in this case, comprising internal lawyers, very experienced in national security cases. Mr. Little, who sits on my right, was involved at the outset and was trial counsel. So we had advice from Mr. Little, we had internal discussions, and then the way these things develop with complex and sensitive cases in the Crown Prosecution Service, senior people have to be consulted. That happened as well. And a decision was taken, which ultimately I endorsed, that we would not be able to meet our test, that there was a realistic prospect of a conviction.
And at what point did you decide that there was no alternative charges that could be pressed? Given the challenges that we'll come on to in a moment, but at what point do you decide there was no alternative charges that you might level at these two, such as plotting to or planning to commit espionage or any other similar legislation?
Well, all this was in the mix, really, at a point at which we concluded that we could not prosecute the case, and that was late August of this year. If I may, perhaps I could just bring in Mr. Little at this point, who was closely involved in advising us on the issue.
So just dealing with a couple of matters that you've raised, perhaps to try and join up some of the dots. The critical meeting, which was an unusual situation for leading counsel for the Crown to meet a witness in these circumstances, and I did that on the 14th of August, and I have a very clear recollection of that meeting because I needed to understand why the two previous attempts to get statements, statement number 2 and statement number 3 from Mr. Collins, why, as it were, what I thought would be relatively straightforward to be said, which was there was an active or current threat to national security, why that hadn't been articulated in clear terms. I also want to make it clear I was not concerned if the witness didn't use the word enemy. That would be a matter for the jury. But I needed to have the evidence to support the submission to the jury. And the witness was clear to me that he would not say that China posed an active threat to national security at the material time. That was in answer to what I regard as the million-dollar question in the case. And once he had said that, the current prosecution for those charges was effectively unsustainable. That's my carefully reflected position. I didn't jump to that immediately. I advised on the 22nd of August, having reflected over it as far as those charges were concerned. There was other discussion then about alternative charges, but I don't think anyone should misunderstand the effect of what the witness had said. That would have been disclosable, and it brought this case effectively to a crashing halt as far as that was concerned with that witness, who is the Deputy National Security Advisor to the Cabinet. It's very different to the position of giving away a witness who witnesses a criminal incident on the street for reasons that I hope are obvious. But we did give very careful consideration as to whether this was remediable. And I concluded, but more importantly we concluded, that is the entire prosecution team, that it was not.
Okay. To bring in Dame Emily, but just briefly, if I could, Lord Hutton.
Yes, a question really for the Director of Public Prosecutions. You said in your opening statement to us that you were disappointed that
Yes.
this prosecution couldn't be brought. And it sounds like you think that there was enough evidence, clearly, to merit a prosecution and a reasonable chance of conviction. And your argument is purely that the Rousseff case changed that.
Essentially, yes. I mean, I was disappointed. We felt that we had a good enough case to prosecute. We'd obviously spent an enormous amount of effort getting the case to the point that we did. And we felt that there should be no difficulty, in fact, in answering the question that we posed. Was China an active threat to national security at the material time? We thought that would be evidence that could be given relatively easily, but it turned out to be a sticking point. We first asked that question, so the ruling in Rousseff came out on the 31st of May 2024. We asked that question on the 11th of June. We slightly amended it the following day. It took 14 months to get the answer to that question, and the answer was no. And it took quite a lot of effort on our part to try and get the answer. But what you can't do as a prosecutor is tell people what to say. You can only obviously ask questions. But we did put a lot of effort into it, and yes, we did feel disappointed and frustrated. This was an important case.
Did it ever sort of occur to either of you that, given that if this case had gone to a trial, a jury would have had to have decided what the threat to national security was? And many people, certainly in this place, would think you can't have national security without economic security. And the Deputy National Security Advisor was very clear of the active threat to our economic security that China posed. And neither of you felt that that was sufficient basis to put an argument to the jury that that in itself could have constituted a threat to our wider security interests.
The question that was posed was, at the material time, was China an active threat to national security? The answer we got with the second statement was it was a threat to economic security. So the question wasn't answered in terms. But if I can just really reiterate what Mr. Little has said, the issue wasn't so much the statements that we were given, it was what was missing. And the key question which would have been posed in cross-examination was the question that we posed in June. Was China an active threat to national security at the material time? And the answer was that confirmation couldn't have been given. Now, can I just explain the impact of that? So the way criminal procedure works, the prosecution lays out its evidence before the court, and at the close of the prosecution case, the defence are entitled to make a submission of no case to answer. And they can do that if any element of the offence is not satisfied. And if the judge concludes that no reasonable jury properly directed could reach that conclusion, then he will stop the case. And the conclusion that was reached by Mr. Little and by our team was we were in that place. So this case would not have got to a jury because our professional assessment was that we were unable to satisfy that limb in view of that answer. So it's not so much the evidence that was given, it was that answer went to the heart of the issues and it was fatal to the case.
Can I
just add
Just bring in Dame Emily.
May I just